Hey, thanks for joining us today. This is Anthony Parent of IRS Medic, and today we have a fantastic episode for you. We are going to be talking about the government's reaction, their reply brief, their response brief in Moore versus United States, along with their allies, and curious who is aligned with them and united with them. Those would be the tax academics, and actually many states filed a brief in support of this as well. So we're going to get to that, and then we also have a couple updates that are going on the Tax Simplification Act, and perhaps some positive news from the U.S. Court of Federal Claims. Joining me today is John Richardson, longtime guest, Citizenship Solutions, and probably the finest immigration attorney, or legal scholar, constitutional scholar on the planet. No hyperbole on that whatsoever. And along with Keith Redmond, who is the global advocate for the American abroad. Thank you, gentlemen, for joining us today. Let's get right into it. So we have this case going on, Moore versus United States, and it is going to be, in my opinion, the biggest tax case of all time, which, if the true Constitution of the United States of America is not the written U.S. Constitution, but rather Title 26, the U.S. income tax and all its ancillary provisions, then this would be the biggest Supreme Court case of all time. So John, you've did some great notes today. Let's get those up here. You wrote an article, and this is where it's going to form the foundation of our discussions today. So let's go over to that. Let me get your article up here, and just taking some time here. And there we go. So we have Moore, the government and the tax academic straight back. There it is. So, John, where should we start off with this? What is this? What is the Moore case really about?
You know, Anthony, there's a saying that the two good trial lawyers are like ships passing in the night, each with a completely different theory of the case. And what's very, very interesting about the government's response, and, supported by, their foot soldiers, the tax academics, right, is their attempt to, I wouldn't say recharacterize the case, but distort the characterization of the case to make it seem like all this is about is U.S. multinationals, that receive benefits in the tax reform, a lower tax rate, move to a partial territorial system. And now, so therefore they're not entitled, to the benefits of, the Moore's possible success. That's either their view of it, which I doubt, for a very simple reason that the Moores are individuals. Okay, it's not more multinational. So I think that that's a deliberate attempt to distort the context of this case on the part of the U.S. government and their foot soldiers, the tax academics.
And that's what, and we're going to go over that, John. Exactly right. Because, I'm seeing this sort of repeated again, the theme repeated again and again. They can't even admit that the Moores are actually individuals. And
now on this point, this is so important, Anthony, because, first of all, in U.S. tax law, okay, there's an old case providing much stronger justification for imposing taxes on a corporation generally. Okay. Basically that individuals, do have, different rights or at least, not enhanced disabilities, so to speak. Right. So to the extent that they're able to keep this thing somehow characterized as about a fight between the U.S. multinationals and the U.S. government, which it clearly is not. I mean, that is such an outright fabrication, distortion of reality. They should be embarrassed. But for these people, believe me, there is no point below which, which they will go. Absolutely none. Okay. So the thing about this is that these are, the Moores are individuals. And by characterizing this as a U.S. multinational issue, they are able to avoid even discussing or even acknowledging the incredible carnage that this law has inflicted on everyday people engaged in activities outside the United States, which are nothing like U.S. corporations generally, but just meet the U.S. Treasury from 1996 Clinton administration rules for deciding what is a corporation. So in 1996, for example, the struggle of Penn, the Clintonites basically sentenced all small business corporations in Canada, even if they're not really used for business, to the CFC designation. Okay. So, I mean, part of it. So my point here, to try to put this, as simply as I can, is this, okay, is that part of the government lie and that part of the tax professional, the professors lie, is the attempt to characterize this as being about U.S. multinationals when it is in fact about individuals who are trying to live their lives as individuals and outside the United States. Okay. This is absolutely critical. It is fantastic. I mean, there's a lot of material. I can't say I've been through it with a fine-tooth comb, but when you read these things, okay, you will never find reference to individuals. All right. And that is part of the distorting reality, what they're trying to do here, right? So we have
Exactly
the
right.
Mueller trial lawyers, two ships passing the night saying, hey, look, you know what? This is about individuals. This is about, and the government saying, oh, no, this is not about individuals.
And
This
I
is
want
about
to, I want to ask,
way
I
with
want to
some-
ask our resident advocate for the Americans abroad, the individuals abroad, Keith Redmond. Keith Redmond, how many calls have you been getting from multinational organizations about the transition tax?
None.
None. How about actual real people with pulses and heartbeats and hopes and dreams? How about that? You've been getting
more than I can count. Individuals, yes.
Yeah, that's interesting. Are you sure they're individuals?
Well, I can only go by what they say to me, and they sound like an individual to me.
Anthony, to give you a sense of how bad this is, go down to the bottom of the article in the appendix, and then we'll go back.
Your article? Sure. Yep, right down here.
Go to the bottom in the appendix. Yep. Now, in the appendix, I'm talking about, slow down, go a little down further, go further, slowly. Click on the bottom link, the very bottom link.
Oh, this one.
Right at the bottom. No. That one. Click there.
Yeah. I opened that up here. I have that up. I have that
All
open
right.
here.
Now,
I was anticipating this. So yeah.
Now, what they've done here, this, by the way, Tax Law Center. Okay. This is, I mean, in a functioning democracy, I mean, we're all entitled to our opinions. Okay. But these are people who are committed. I mean, they've never seen a tax they didn't like. Okay.
I mean, this is really something. Yeah. I mean, it was difficult to read this, and this is sort of what's
keep going down to the guide. And I want to show you something interesting. Links to briefs of parties. Now.
Yes. Okay. You're the same thing. Yep. Okay.
Keep
yep.
Going, come on. Keep going. Now, stop. Go up a little bit. Stop right there for a minute.
Yeah.
Okay. Now.
Yep.
Sorry, it's not that one at all. Now, what they've done here is they're, sort of, in the public good. We're going to put all the briefs up, all the amicus briefs. Now, they've tried to put them into categories. Now, there are only 2 amicus briefs, period, that not only discuss this in the context of individuals, but make the point that individuals are being treated very, very differently. One of them is the seat brief, and the other is the brief of the individual people. The Suzanne Herman is included. Now, let me just show you, because what I want you to see is how Tax Center has deliberately omitted a category of briefs that discuss the individuals, and they have put it literally. Keep going down slowly now. Slowly. Keep going. Hold on. Keep going. Hold on. Oh, now they do have, actually interesting, they do have individual taxpayers. Now stop there. Now, what I want you to notice is that they have created a category called briefs providing business perspectives. Keith, I got a question for you. Do you think that the purpose of the seat brief was to provide a business perspective on the transition tax? Yes or no?
Keith, you're muted right now, Keith.
This is part of the lie here.
Yeah.
Okay.
No, and that's what truly, it was so obnoxious. And because, the tax law center claims to be nonpartisan.
Okay, just stop for a second, Anthony. Let's stay focused. Now, I'd like you to click on the two individual taxpayers. That's Suzanne's brief, and then
Yep.
see below. Click on it.
Okay.
Either one. Now, let's see how they characterize this. Let's see how they characterize it. No, somehow. Okay.
I think I think they don't even link to it.
No, they do.
Yes.
Because I saw their description of the seat one. Then click on the seat one.
All right.
Click on that.
And
Just
hold on a
Go,
second.
click on stop.
Yeah, hold on. It opened up in a different window. Hang on one second. Okay. Okay, I think it's the same. It links to the same page, John.
All right, let me pull it up on my laptop because this is critical because I want to show you how they distort the seat brief as well.
Okay.
Okay. And by the way, these are and of course they applaud Matthew Gardner. Remember that article we talked about?
Oh, right. Well, you know what? And years ago, I remember having a conversation with one of my attorneys, Robert Hansen, fantastic international attorney. And he was, we were having just one of our discussions about, normally, taxes, around having coffee. We talked about this. We talked about, he's like, well, if you think about it, every tax professor has their turf. And so, the discussion went something like this. And so this is sort of how I've always thought about it since this discussion is that you want to think of the entire US tax code as turf, and think about it like a criminal organization would think about turf, and you carve up the turf and everybody gets their own fiefdom. Now, whatever fiefdom you get, it doesn't matter what it is, but it becomes the most important part of the tax code. And then as a tax professor, you go deep into that section. Hey, and if someone else comes in, no worries, because it's so expansive, there's always room for something more. You just niche down a little bit more until you are an expert on this particular thing. And so what happens is that every tax professor that we run in is looking to make sure that they all work in conjunction to protect the overall scheme. So they will all come to each other's defense and say, no, that section's absolutely essential. Because what you need to understand, why all of these tax academics are so bloodthirsty for other people's revenue, and for a law that isn't going to affect them. Of course, it doesn't affect them. So the reason why is because this is their entire livelihood. Their entire identity, their professional, the reason why they get invited to places, the reason why they get paid the amount they do is because of the tax code. The tax code gives them the biggest benefit of all time. It makes them the Lord and master and someone who's relevant. And so this is what is fascinating to me is that I'm seeing this theory that Robert and I kind of came up with probably 10 years ago. He was just, here it is coming to life. This is it, front and center. This is it. The tax academics are adamant. Hey, look, and I would say this, that if you think about it, John, that the tax academics are sort of franchisees of the United States government. They're like, okay, we're going to give you this turf. You kind of self-select your own turf. But hey, look, you're going to be out there pushing this, why it's so important, and you're going to be talking endlessly about its various complications. Because, hey, look, that's how you're going to get a nice salary as a tax professor. And you're going to be talking about something actually only 20 people in the world understand. So no one's really ever going to call you out for being wrong, except maybe a little podcast such as ours, who's calling it out. So that's always what I've seen as, that's what I'm seeing, this theory of ours come into fruition. And I think it's becoming, painfully obvious, what we're really dealing with. John, were you able to pull it up?
Yeah, I got it here.
Okay.
So look, again, to put this in context right now, this is the category that they're calling briefs providing business perspectives, right? So all the briefs under here, they're to provide business perspectives, okay? Now, the seat one, of course, is at the bottom here. Well, it is at the bottom. I'm not saying it's tending to be at the bottom, but the point is simply this: that the seat brief is not to provide business perspectives at all. It's to lay out exactly how this affects Americans abroad, and they don't want to have that conversation.
No.
Here's how they describe it. Since you're having trouble with your clicking, I clicked on mine on my laptop. This brief filed by 2 French organizations. Technically true, but not so much, really. Okay, this is about individual Americans abroad that they want to talk about, that focus on overseas Americans and extraterritorial applications of U.S. tax. Argue that 965 is applied to individuals, is taxation based on nationality rather than residency. Includes that violates equal protection, the United States obligations under bilateral tax treaties and other nations' sovereignty, seat in error or co-counsel. Now, that's an example of lying, distortion through omission. I mean, all of that is true, all right, but what it really says that this lays out the carnage of how this affects individual taxpayers when you import the U.S. citizenship taxation system outside the country. That's what it should have said. Okay, and I think they clearly know better. Now, if we click on the individual taxpayers thing, okay, here's what it says about that. This brief filed on behalf of individual United States citizens who hold shares in controlled foreign corporations argues that 965 is unconstitutional and harm and created uncertainty.
Oh, okay, yeah, I was able to get it, John. I see what I see. Yep. Okay. Yeah.
Okay. So, I mean, yeah, sort of. Well, if anybody read the brief and saw who the people described were, again, it's Americans abroad. So what's happening here is that, I'm going to put this real simple, okay, that these tax professors are basically, I don't know whether intentionally or accidentally, but they are coming together to protect anybody finding about one of America's dirtiest secrets. Okay, where they're trying to impose this crap on people who live outside the United States. That's what these things, and there ought to be a category for how this affects individuals. Look at this, putting this under business perspectives. Are you kidding me?
All right. Hey, Keith, a question to you, Keith. Would you say this is in line, how the tax professors are sort of framing the argument is sort of the same? It's a common theme. Would you say that we're just going to disregard that there's actual people overseas? Would you say, we lost Keith again. But I think that's what we have here again, once again.
Anthony, there is no question about that. They want to talk about anything but individuals.
Right.
Anything.
And they want to talk about anything other than this tax as applied.
Exactly.
Hey, we don't want to talk about that, but look at
individuals. I mean, this is absolutely shocking. Now, when you read their stuff, I wrote sort of a summary of what I think they're trying to say, which I wrote this morning. Maybe go back up there.
Yeah. I think I just want to stop, because I wanted to hit this because you started off this article just sort of essentially, we need to set up what's the 16th Amendment important for, why, and really at this point, this is, and as I was going through the brief, I do really see why the government and the tax academics are freaking out, because it's point blank. We're going to need, income in order to, like the Supreme Court could certainly, let me get that link here. The 16th Amendment here, up here. Let's get this here. So the Supreme Court could certainly take away all of these deemed income events, which another way to say deemed income is called fake income. Your income didn't happen, but we're going to call it income. They could destroy so much of the tax regime that they built up over the years, and they've really gotten used to that. They've really gotten used to how getting money, getting tax, getting revenue from non-income events. It's
worse than that. If you look at Professor Aviona's brief, okay, I mean, what he says is that fake income is necessary for the U.S. tax system to function.
Oh God! I'm not gonna click on that. Right? Yeah.
That's exactly what he says. Okay, I mean, not in quite those words. I mean, it has to be masked to give it a sense of moral legitimacy. Okay, yeah. But I mean, that's what he's saying. Imagine that. we have to be able to tax fake income to have a functioning tax system.
Yeah, right on. We got a great comment from Melvin. You know,
The national anthem of the
there you go.
tax.
Thank you, Melvin. Thank you, Melvin. The tax is devised by persons that are absolutely not affected by the law. And it's there you go. All these tax academics, you know, because here was actually the analogy I want to think of, because we're talking about over these. What is this tax? How does it actually work? Well, if you're a shareholder in a corporation, you get your distributions, okay, and you're taxed on that, okay, no big surprise. But what this transition tax does, it taxes you on the shareholder equity of the corporation, and that's the asset of the corporation. Your asset's the stock in the corporation. So it's claiming kind of a double thing here. Well, you have your stock, which is worth something, but you also have the shareholder equity. So it's double counting. It's double counting, and that shareholder's equity isn't really something that exists. It's there, but who knows what's going to happen to it? It may have to be reinvested, and you're just a shareholder. You actually don't have the right to that. So what the tax code is doing, in a way, is destroying corporate law. You're saying, well, we're going to say your shareholder equity actually is also shareholders' present value. It's in their possession, other than their distributions. Total nonsense. So this is where they're going so incredibly far in this. And they don't even want to admit to the facts of this. They have to lie and you know, talk about everything other than the issue. And here we go. So I just wanted to insert that right there. So John, the 16th Amendment, maybe a little quick history lesson for people about 16th Amendment.
Okay, this is going to be really, really quick. And I suggest, speaking of tax academics, that people read the brief of Professor Ackerman, he's near you, Anthony. He's a Yale academic. All right.
Yeah.
Now, very rich in his thinking. Okay. But of course, very biased. So his view of this is that, so we look at the history of this, right, and the meaning of the 16th Amendment. All right. So what he's saying is that to understand the 16th Amendment, you really should not be looking at what it says. Okay. You should be looking at the context in which it was enacted. And what happened was that for 100 years, there was a rich, well-developed, loved American tradition of attributing the income of a corporation to the individual. That's the American way. That's what we do. Look, there's a corporation. Why don't we make the individual pay the tax? This is American tax law is rich in this tradition. Okay. It's like, you know, the tax professors probably should have their own equivalent of Thanksgiving every year, you know, where they celebrate these types of things. But his point was that basically what happened with the Pollock case is that the court held that income from dividends, interest, etc., did not meet the test of income for taxation. Okay, because for all kinds of reasons that are too complicated for me to get into, right? So it was interpreted as being, and I think there's some justification for this, right? Saying, oh my God, the Supreme Court has just ruled that people who get their income from investments don't have to pay tax on that, okay? And it's only the working stiff who has to pay tax. Now, I agree that that's, you know, a pretty bad proposition, but his point was that the 16th Amendment was not only an attempt to overrule the Pollock decision, right? So here's where they get saying, oh my God, what are you kidding me? You know, we're going to exempt income from interest, dividends from taxation. No, here's what we're going to do. The 16th Amendment is Congress shall have the power to lay and collect tax on incomes from whatever source derived, right? Right. So this is an attempt, okay, to say, come on now, you know, we're not going to let the judges carve out certain kinds of income, you know, for wealthy people who, you know, to allow them to avoid taxation. Right. So now what's interesting about Professor Ackerman's brief, if I'm reading this correctly, is that he views the 16th Amendment as essentially a congressional response to protect the government from the Supreme Court, right? In case the Supreme Court decides that we're gonna carve out some kind of tax, all right, that wouldn't apply to wealthy people, right? Now, let's go back to the 16th Amendment. Now, that does not mean, okay, that somehow it's restricted to that context, but that's how he views it, right? In other words, he views the 16th Amendment not as a limitation on what government can tax as income, but rather as a constitutional guarantee that the government can tax anything as income, right? That's how he views it. It's very
Well,
interesting.
I think he's right. I mean, I see some, I really see that. I kind of see that as being like, no, we don't, the Supreme Court, because, and essentially that's what happened. The Supreme Court, they passed an income tax. Supreme Court says, nope, you're not going to do this. Okay, well, what are we going to do? We're going to make it bulletproof so the Supreme Court can't rule against whatever tax whatever income tax we want to impose.
Right. Now, assuming that's the case, and again, I mean, this to really analyze this, you've got to get into so many years of history and that. And I'm at my limit for what I can do.
Yeah.
But anyway, so here's what we then have, right? And this is fundamental to, I think lots of the government and tax academics argument here that if we look at this now, and let's say that we understand it contextually to be, we must protect the government from the Supreme Court doing something like this. Now we have kind of the power to lay tax on incomes. Notice there's no requirement of realization. It doesn't say, it's incredibly broad incomes. Now, on that point, the tax center, I think correctly made the point that Kissincraft did have income, and maybe the Moores didn't, but Kissincraft did. So there was income to be taxed. Income from whatever source derived. Well, whatever source, look, it never says there that, the individual taxed on the income has to have received the income. I mean, what's wrong with, getting Anthony to pay the taxes of income, from his neighbor across the street? No problem. This is the 16th Amendment. It allows this stuff, right? So if you read it in that way, you can begin to understand the foundations of the government's argument, which is, all right, yeah, you got to have income, but does it have to be realized? They'd say, no. It's just an administrative convenience. Anything, let there be income, there was income, okay? And then they say, from whatever source. So, well, the source of our taxing you, buddy, is your rich neighbor. We like your rich neighbor. We don't want him paying tax. So you know what? We're going to make you pay the tax on his income. All right? I mean, that's how they're reading this thing.
Well, John, and you just sort of brought me up to our larger point that, you and I have been, and on this channel, if you've been a fan of this channel, one of our realizations is that the true Constitution of the United States of America is the income tax. And as I'm looking at this, I'm looking at the text of the 16th Amendment right now. What's going through my mind is, well, actually, this is the true Constitution, because what's not discussed or what's diminished is how the rest of the Constitution works and how the rest of the Bill of Rights works. We're supposed to be free of unreasonable government searches and seizures. Okay, that's Fourth Amendment, right? Well, the Fourth Amendment, but meanwhile, the income tax code, if you actually read it carefully, says the commissioner of, or the first one said, the commissioner of revenue shall canvass everyone to determine what their income is. That is, meaning to go out and investigate everyone's life. They have the authority to do that. And so, you would say, well, geez, that seems like an unreasonable search and seizure. Yes, but it's for taxes. Therefore, the Fourth Amendment, it doesn't matter anymore. It goes away. And as we go through the rest of the Bill of Rights, we go through everything, time and time again, what will always beat out everything else is the 16th Amendment. And here we have a situation where it's not looking so good for the government as a Supreme Court. And this is I think the point that I saw here. And this is really the question presented in the case. Okay, this is the key. Whether the 16th Amendment authorizes Congress to tax unrealized sums without apportionment among the states. Now, the transition tax, as you wrote, this was not necessarily the argument of the Moores as they were going up, but rather, correct me if I'm wrong, this is the question that the Supreme Court wants to resolve.
Well, this is the question that the Moores lawyers have decided they want to get the court
Oh,
to
okay.
rule on it. Okay. Now, if we go through the history of this thing briefly, there were two arguments that were made, okay, in the district court and was it the Ninth Circuit, whatever the damn thing was. Okay, anyway, the two arguments that were made were one, okay, that it wasn't an income tax, that it was a wealth tax. The second argument that was made was the retroactivity argument. Now, I'd like to discuss in a minute the retroactivity argument because I actually think that's the key here. Now,
Okay.
for reasons that are inexplicable, well, you know what? They did get the case before the Supreme Court, so you've got to give them credit for that. But I think that the bigger issue here is the retroactivity. But in any case,
Okay.
the way, if you look at the the proposal, right, the cert petition, that's how they framed this thing. Now, the pension intellectuals, the tax profs, of course, are upset because they see this as, if you have to have a realization requirement, then, I mean, how can Elizabeth Warren get her wealth tax through and stuff like that? I mean, this is very upsetting to a tax intellectual.
Mm.
Okay. So, that's where we are with it. I do think, though, the context matters, okay, that, this is a case about individuals. And I want to add here that I think that what the court can do here is say, as per the situation with individuals, we're going to strike this down. Okay. We'll leave the corporate thing intact, but we're going to strike this down in the case of individuals. For a variety of reasons.
Mhm.
Okay. One, they never got any benefits, nothing at all. They just had their pensions confiscated. They never got any benefits at all.
Yeah.
Um,
Yeah, they're not a large multinational corporation.
yeah,
No, they're not.
but,
No.
but you want to notice here how, see, the Moore's lawyers abandoned the retroactivity argument, which I think was, and this is just my opinion, what do I know, right? But I think this was a gigantic error because I think they're misreading or haven't read carefully enough the Supreme Court decisions on retroactivity. There's a case called Carlton where Justice O'Connor, in a concurring opinion, says flat out, there has never been a case where we have allowed the government to make up a new tax and apply it retroactively. Right? This is what O'Connor
Yeah.
says. Now,
Yeah.
what these people are trying to argue is, and I think this is completely disingenuous. Well, one more example of their
Yeah.
disingenuous.
One more. Yeah.
But they're claiming that the transition tax is not a new tax. And they claim this for two completely idiotic reasons. They're absolutely idiotic. Okay. The first is that, well, look, it appears under subpart F. We've always had
I
subpart F.
know.
This is what they actually say.
I know. How can you do that? In subpart F, it's fine. And again, that goes to
Are
the.
they completely out of their minds? Let's test this differently. Let's say that instead of putting it in subpart F, which they didn't have, they didn't have to, they just put it under section 61 as just another thing that should be taxed.
Sure.
Would they then
Yeah.
take the position that this is not a new tax? Of course they wouldn't. They realize the absurdity of their position.
No.
All right. So, that's the first, the first sort of, point they make. All right. In terms of the, in terms of why the law does not allow this thing to be struck down based on retroactivity. It's not a new tax. Then they make the claim, and this is, as far as I can see, absolute indescribable bullshit. That in fact, this was always deferred income that was going to be taxed anyway. Now, I may be wrong on this. Okay, and I've got to tell you, it's pretty hard to keep up with all this nonsense as they keep shooting it by my head as I try to read it. But I've got to tell you that I cannot find anything in the tax code before Section 965 that creates deferred income to be taxed. Right? And it was not, this was not income that was always supposed to be taxed, that was tax deferred. This was income that simply wasn't subject to U.S. taxation until
It's
they
not income.
made a new tax
Yeah.
in 2017. So the point is, this is a new tax. Now, let's move to Justice O'Connor's concurrence in the Carlton case, where she says, now they didn't anticipate, this, I think, right? But what she says is, there's never been a case where we, let the government make up a new tax and pay it and charge it retroactively. This is a brand new tax. No question about how do we know it's a brand new tax? Because it didn't exist before they enacted it. Okay? I know that concept is too simple for the tax academic, okay? But it is a new tax. Okay. And the question becomes, can they just make up a new tax and apply it retroactively? Well, not according to Justice O'Connor. Okay, not according to Justice. So in other words, this argument needs to have been developed better. And you will see also that the government brief and the tax center brief are nervous about the retroactivity argument. Okay, and a couple things that they've said about it.
Now, and I want to, and I did go to tax I did go to their the government's brief or their so joining tax academics in this are 16 states and the District of Columbia. Believe it or not, the District of Columbia is in favor of this tax. I know you're having a hard time believing that. I know. And these briefs, get really kind of comical as we're going. I was reading these. They're acting like, because the states are acting like they're protecting the rights of people because the MRT. Because here's the argument of the states from their briefs. The MRT, the transition tax, was a crucial transitional provision in a major tax reduction package. So it's like, well, hey, look, what are you doing? Taking away the tax savings is as their argument is.
For who, Anthony? Tax reduction for who?
Yeah, exactly. There you go.
Corporations, not the
corporations. So here it is. These tax academics are purely in the camp of the people who got the reduction of the taxes, but against those who have to pay the bill, which are individuals. Now, this is going to be now, John. In the United States of America, we have think tanks, we have all these academic institutions. They're all nonprofits, right? They're all nonprofits.
Means so they don't pay tax on their profits. That's
right. So yeah, right. They're nonprofits. What's the well, sorry, I gave it away there. What's the business entity of all of these? What business entity are they all?
I don't know. What do you ask me? Are these 501(c)s or something? Is that
they are all corporations.
Oh, yeah.
Right. They're corporations who just don't have shareholders. And so this is what I was thinking of. I was like, well, okay, so if the Moores are taxed, because of their relationship, they're shareholders of this. Well, a nonprofit doesn't have any shareholders. So you need to go say, well, who are the stakeholders? Who are the stakeholders? Who are the effective shareholders of a nonprofit? And the answer is you'd say, well, I would say the people who work there. I would say, well, everybody who works for a nonprofit is a stakeholder in a nonprofit. And so then I would say, well, geez, what I think we should do then is I think we should attribute the earnings and profits and whatever fundraisers are there, that not, it's the equity of the nonprofit that doesn't have to be split out to shareholders. I think that should be taxed. Maybe then all these tax professors would change their tune. If you're like, all right, well, we're going to tax you on the phantom income of the corporation for which you work for. For the corporation because, hey, look, you guys got out of income taxes, but however, it's still there. And then perhaps that would say, oh, I think they would. Do you think they would change their tune, John, if they had to pay for this?
What I think is that I think that as a group, these people don't even understand what's going on. Okay.
Well, yeah, no, and I mean, here's the Act's foreign income. This is from their brief. The Act's foreign income provision substantially eliminated taxation on distributions to U.S. companies by control.
Stop right there. That is an outright. They're either incredibly ignorant, incredibly stupid, or they're outright liars. Now let's take that apart. Okay, who wrote this anyway?
This is the brief written by this thing is let me go back up here. This is who it is. It is Amicus brief for the states of Arizona, all these states here. Connecticut, unfortunately, joined
Okay,
this.
go back down to the paragraph.
Let me go back to 31. That's where I
Let's take
was.
this apart. Let's take this apart.
Yeah,
okay?
yeah. Or 30, I think, or was that 21? Sorry about that. I'll get back to where we were quickly. My memory is. Where is it here? I think 21. Hopefully that's where it was. Hopefully I'm somewhere around here. Oh boy. Oh, I lost my speech, John.
No, find it. This is important. Now,
All
keep
right.
going.
It is very important, right? And maybe someone could comment to say what page I was on. Ah, boy. Sorry about that, folks.
Okay,
Let me
look.
just-
Okay, here's what it said in substance, right? What it was saying was that the Tax Cuts and Jobs Act, through amendments to the Internal Revenue Code, eliminated future taxation on distributions from controlled foreign corporations. Okay, that's what they were trying to say. And they point to Section 245A of the Internal Revenue Code, which enacts what internationally is called a participation exemption. In other words, I mean, this is trying to bring the United States in line with international standards. Now, what they're saying, okay, is that from the 17th of November, they are saying that these corporations can now distribute profits from CFCs tax-free. Now, listen to me very, very carefully. That is absolutely false. I'm going to say it again. That is absolutely false. The reason is because of the GILTI tax. At the same time they made this change enacting 245A. They also enacted 951A. I think the lesson here is beware of sections of the Internal Revenue Code with a capital A. 877A, the expatriation tax, okay? That's for those who can't read, okay, to find important provisions, all right? But what's extremely significant here is that while on the one hand they claimed, you remember made the media, that we're moving to a territorial system of taxation. On the other hand, they said, well, I mean, we can't really let these people have tax-free distributions unless, well, we've already taxed them first. So what they do, the purpose of the GILTI thing is to tax them first, tax those profits first, maybe not as high of a rate, okay, but I'm just trying to point out the absurdity of the statement. So they tax those profits first, so the corporations are taxed as a pass-through, and then they say, because we're so fair, just, and magnanimous, we're not going to tax them when you take them out, when you finally take them out. So, what's so absurd about this? So absurd about it is that when the United States moved to a system of territorial taxation, supposedly wink wink, under 245A, by enacting the GILTI rules, what they actually did was expanded the territory over which they were exercising tax jurisdiction. Now that's the truth.
You're right. You're right.
That's the truth. That's the truth.
Right.
Where are the tax profs making that point?
Well, and this is sort of an odd thing that okay, I live in Connecticut. Did you know that Connecticut has universal tax jurisdiction no matter where I go in the world? Connecticut's not a country, it's a state with it. It's a state. But as a Connecticut citizen, wherever I go and make money around the world, it's subject to Connecticut taxes. Kind of an odd thing if I think about it. Okay, so we know in Cook versus Tate, which is not really a tax case, but it's expressing the relationship between the government and its people under the 1924 understanding of what that meant. If we take a look at that, we are we're stuck in a situation where this is gone. I lost my train of thought there, John. Help me out here. Help me out, John. I got a little bit out there in one of my tangents internally in my brain. Bring me back to earth, John.
The problem is, all of this is part of a theme where the United States is a nation of laws, for sure, but it's also a nation of laws that are so complex that nobody can even understand what they mean. Okay, and
Right.
this is true of tax. It's true of immigration.
Every,
It's
yeah,
true.
everything. Yeah.
It's true of election laws. So essentially, you're just dealing with a labyrinth of rules interpreted without context, generally applied punitively and selectively, where people have got to get out of the place. Okay. I mean, anybody can justify any position they want by reading selectively or thinking selectively. It's like, the claim that Section 245A means that the United States has moved to territorial taxation. Well, all right. You would get that if you just read 245A. Okay, but if you also read 951A, you'll see nothing could be further from the truth. So, I don't know. Anyway,
Yeah, I would say this. Here's a nice quote though in the state's briefs. There's a nice quote from Speaker of the House, Paul Ryan, who, as you remember, was removed. He didn't run for re-election. He had a little bit of a hard time there. He is the self-identified drafter of this. Okay, and here's his statement: the goal was to finance a conversion from one system to another, and it wasn't to justify a wealth tax. Okay, so I think petitioner's lawsuit is a misguided challenge, in my opinion. And the point of that was just a temporary conversion from worldwide to a territorial system. We probably tested this idea for a good 6 years before we put it into law. I can't really understand it. It's like, well, when did we convert from a worldwide to a territorial system? When did that happen? I missed
When
that.
was that tested? Yeah, I've been at this for a while. I don't remember this.
Right. I'm like, so it's like, okay, when was this? What are you talking about? This idea was tested for 6 years. And so they're like, this is a ridiculous statement. So the point of this was just a temporary conversion from worldwide to a territorial. Oh, okay. So the temporary conversion was just at that moment. It was the moment of the tax. And as soon as you pay the tax, now we're back to worldwide jurisdiction. Is that what he means? That, well, we're gonna make this a territorial system for 1 second and 1 second only when this tax is due, and then after you pay it, then we're gonna go back because that's how it reads. There's never been a trend. What is he talking about?
Anthony, how about this? That paragraph has nothing whatsoever to do with the issue. Whether it's true, false, or indifferent is completely irrelevant.
Yeah.
Okay?
Just a
What's
politician
relevant,
talking about his law.
what's relevant is this, okay? This is a retroactive tax, retroactively imposed on 30 years of income that applies to individuals who don't live outside the United States and has confiscated their pensions. That's what's relevant here, okay? So in other words, what's very interesting about this dynamic, okay, is, the modus operandi of the tax prof is that what you do is you make up a bunch of theoretical nonsense, which they, by the way, do not understand. Okay, they do not understand it. For them, this is just a bunch of ideas. All right, a better LLM and tax. You want an LLM and tax? Don't go to these schools. What you do is you say, you know what? I'm going to divide my year into 12 different ways of life. Way one, I'm going to live as a homeless person on the street. Way two, I'm going to live as an undocumented immigrant. Way three, I'm going to live as an American abroad expat. Way four, I'm going to behave as an American abroad immigrant. Way five, okay, perhaps an accidental American. Way six, a black person, okay, etc. That gives you your LLM and tax. I mean, they are just completely out of their minds. Okay, they're out of their minds. They have no idea what they're talking about. I mean, this is extraordinary stuff.
They get paid to be disconnected from reality.
They're completely.
I mean, that's really what they're doing. They're so.
It's worse. They don't even understand the theory. These claims of, well, the United States has moved to a territory under two. I mean, they don't even understand.
Yeah, what did that happen?
So, gentlemen, if I may interrupt for a second, based on your back and forth and so forth, how do you see this going? What I'm gleaning from what you're saying is it's not going to go well for Americans overseas that have to deal with the transition tax. That's what I'm gleaning from what you're saying.
No, actually,
correct?
Thank you very much. Thank you very much, Keith. And I would say, and I think Melvin's comment here sums up what we're discussing about is how much all of these briefs are muddying the waters, and that they're talking about things that they don't want. They're trying to talk about the things they want to talk about, not what the case is actually about. Because what the case is actually about is
Yeah.
pretty clear cut. We have that the Moors are certainly a tax on income they never received nor may ever receive. That's a fact. That is a fact.
Right.
And of course, when
Right.
you're dealing, hey, look, when you're dealing with bad facts, change the facts. And that's what they're doing. So they're changing the facts, throwing all this nonsense out there. And it can't distract from the fact that the Moors are real people who really had to pay about $14,000 of tax on income they never received nor may ever receive. And that's the facts. And so that's what they don't want to talk about. What they want to talk about is everything else. And that's really, I think, the purpose of, what we're trying to get to is look how dishonest they are. Look how dishonest they are in their arguments.
So Anthony and John, being not a lawyer, and the two amicus briefs that were filed, Suzanne and Seat, how does that play into it when it comes to December 5th? Is that addressed at all? I'm coming at it as a novice with the amicus briefs. What happens with those briefs? Because it's talking about the individual. So does that mean that it'll come up during the arguments? Or is it just something that you just submit and that's it? Just for the audience that just doesn't know a lot about this stuff, what does that mean?
Thank you, Keith. Thank you for that question. So the amicus briefs may or may not be read by the Supreme Court justices. Typically, all the clerks will read all the briefs because in there might be there might be a golden nugget of an argument. There might be something that's worded in a particular way, and then that would bring the attention to like, hey, look, and the clerks are going to know how the judges are going to rule. They're going to say, hey, look, I want to rule in this way. Find me a way to do it, and then that's part of their research. And so an amicus brief can be incredibly helpful. By arguing in a different way that maybe the respondents or petitioners didn't argue. So it is something that I wouldn't that it's not something that is going to be addressed likely at oral argument, but argument things in there, elements can be addressed in relation, and the things that, because it's just there's so much to taxation that it's hard for any petitioner to get it all out, and this gives other people sort of the chance to hey, look, have our say. And there's certainly a chance that a clerk could read it, and it's certainly a chance that if something's good in there, that would be relayed to a justice writing an opinion to say, okay, yeah, let's include something like that. That's pretty solid reasoning.
So do you think by the amicus briefs talking about the individual, and when clerks read it, there may be a propensity that one of the justices may ask a question about the individual?
Sure, absolutely. No, and I think that too, and I don't think that, and I don't, just because the argument, the government and the academics are dehumanizing people, I don't know if that's really going to fly that far with the Supreme Court. They know what this case is about. The Moors are actual people, and they understand that. Well, look, and I mean, this also goes when you're trying to decide cases. You're like, well, look at what the government has to do. They have to really They don't really want to talk about the issue. They want to talk about a different issue. And that's usually an indicator the person's going to lose on this issue, that they're like, well, you have a losing, you're wrong on the facts and the argument. So, and really what they're doing is they're creating different facts, and they're creating, different law because they're just wrong every which way. And they're exposed. And I think, what's great about this is how great it exposed the whole collaboration between deep academia and deep state. They're the same people. They work for the same places. They have the same idea. There's no separation. I mean, isn't it crazy that not one of these tax professors, they're all sort of like in lockstep. Oh yeah, it's all a great thing. Oh yeah, it's all a great thing. I guess they had they have conferences where they all go together. It's like, yeah, we need this. And again, it's because of their inherent bias. They will always want the tax code to be as big and expansive as possible because they have a vested stake. Their entire life is designed, it requires the tax code to be as terrifying as possible because that's what gives them their whole rationale for existing in life. They have nothing else. There's nothing. Yeah. So that's what I would say is that the briefs that have been filed, I would expect many of them to be read by the clerks, and the clerks are really the ones who are doing the bulk of the legwork in this case. Now, the other thing too, though, we have to understand this is a different case than everything else. And again, as I say, I think it's the most important tax case of all time. therefore the most important Supreme Court case of all time, is my reasoning. So, we might even see some that would Justice Thomas read these briefs? I would say, yeah, maybe. Alito, as they are, as the groundwork is has been out since April. Since April, they've been laying the groundwork at least to diminish them. So those are the ones who I think are probably the ones most likely to do it, because there's probably been some sort of leak. Just like the Dobbs decision was leaked to the press, there's probably some sort of leak where like, hey, look out, the Supreme Court might actually require income an income in order to be taxed. So this is what I would say. So my bottom line on the government's reply brief and the tax academics and the states is that they know they have a losing issue and they want to talk about everything other than the issue. And as Melvin said, they're just muddying the water to try to confuse. And things they're saying are just totally not true. And they're trying to go to these state scare tactics. If you do this, the whole system's going to fall apart. What that actually would sell me on it, but I don't think so. Unfortunately, I don't think so. And so they don't want to argue honestly. And that's the bottom line, is they don't want to argue honestly. And I don't think that's going to play well. I don't think it's going to play well at oral argument and the decision. John, what would you say the summary of the government's and academics' reaction is?
Well, I think I would start off by saying, get out of the United States. The tax profs are running the lunatic asylum. Okay, I think I would perhaps start with something like that.
Yeah.
So the tax professors and the government go to great lengths to make this absolutely outrageous claim that if the Moors win, somehow this will upend numerous provisions in the U.S. tax system. And I would suggest that listeners read a brief, an amicus filed by Mark E. Berg, who wrote an amicus precisely, to point out the absurdity of that position. And as I read it quickly, okay, but as I understand it, he's saying that what distinguishes the transition tax from all these other things they're talking about is that, subpart F, for example, or the grantor trust rules, or partnership taxation, all deal with taxation of current income. It's just a question of, who gets dinged with the income, right? And his point, which is absolutely correct, is the transition tax doesn't deal with current income at all. It deals with past income. It's completely retroactive. So there's no problem striking down the transition tax on that basis and leaving everything else intact. Now, both the U.S. government and the tax center people are clearly nervous about the retroactivity argument. I included in the thing I wrote, some excerpts where they try to, what they really are saying is, well, retroactivity might have mattered, but hey, you didn't raise in the Supreme Court, which is really what they're saying. But I think it's entirely possible for the court. Remember with the Obamacare litigation at the very end, Justice Roberts ruled in favor of the government just out of thin air by saying, well, this is a tax. It's a tax. It's nothing to do with Medicare. It's a tax. So why don't we just uphold it?
16th Amendment is right.
Maybe
True Constitution.
what the Supreme Court can do this time is say, well, it's retroactive and we're not going to uphold this with respect to individuals. They can do that. And that's what I would hope that they do. What will the court do? I don't know.
I just put the Berg amicus brief in the super chat there, so you can follow a link.
Yeah, I think it's among the best briefs there. I would read it. He makes the points very, very. Well, obviously, partly because I agree with him, but he makes the points, very, very succinctly, and this is why retroactivity matters. It's also, by the way, the thing that distinguishes. The transition tax, which is going backwards, creating income retroactively going backwards from things like guilty, from subpart F, the grantor trust rules, partnership, all these kinds of things, right? It really is a very, very different exercise. Now, why the government, um, why they don't admit that this shouldn't apply to individuals, rather than trying to pretend they don't exist. I don't really understand that. But it is what it is. I think that, it's going to be very, very interesting to see what happens on this.
And I
Remember,
would just, I want to,
remember, Anthony, the Justices Thomas and Alito, I think, went to Yale Law School.
yeah, I'll have to do that. So I do want to share some updates just with everybody, some things yesterday. And thank you very much, John. Thank you for your summary on this. I think, this is, we basically have, we don't have the greatest arguments coming from the government and the tax academics. They don't really want to discuss the issue. We have some updates, other updates we want to talk about. Yesterday, there was Congressman Don Beyer had a webinar on the Tax Simplification for Americans Abroad Act. We had a podcast on that. I have my own opinion on that. I believe it to be a Trojan horse to correct significant errors with the Bank Secrecy Act that really doesn't allow for FR penalties to be assessed. This act magically cures it, though, by the way. And so here's a link. I'm going to put a link to that because this video is unlisted, so you might not find it on YouTube, but there is the link. I just put it in the chat right there. You can get. And then lastly, this is where I want to finish our discussion today. There's some good news to a degree because this decision may really be appealed. Why is it not going to my screen here? I'm not getting the right screen share here. Why is I'm not getting that? I'm trying to get this decision up here. What are we doing here? Hang on one second, folks. Let me do this again. Let me just show. We have a decision out of the Federal Court of Claims that's in favor of the taxpayers. So good news for the taxpayers. And it was on the net investment tax and the application of tax credits from France. So this was a victory yesterday. We just got this. We're trying to get the decision. We went to the Federal Court of Federal Claims website. We all did. We couldn't find the decision. So John's going to reach out to the judge to try to see if he can get the actual decision out. But here we go. We have the IRS has been improperly engaging in double taxation by requirement payment of the 3.8 net investment income tax, known as the Obamacare tax, on income that has already been subjected to foreign taxes. In this case, and essentially what this is about is that taxpayers paid a 30% tax on capital gain in 2015 from the sales of a French company. And while the IRS has allowed the Christiansens to offset the 20% of U.S. capital gains on this gain with the French taxes they paid, the IRS denied their right to use the remaining 10% of French tax paid to offset the 3.8% Obamacare tax on the gain, with the effect of they paid a total of a 33.8% tax with a double taxation amount of $3,851. Well, they won here. Now, John, you believe the government's going to appeal on this?
Yeah, and I think the government's going to win on the appeal.
Well, all right. All right. Well, we'll see. Stuart Horwich of Horwich Law was the attorney representing him. Congratulations on him. Now, this is what I think is interesting. If there was a takeaway on this case that is really helpful, and it's right here. It's at the end. I believe it's at the end. It is going to be here. Where can I
Go down to the notes there. Get down further.
Yeah, no, I'm looking for the note because I read it here that essentially I'm trying to find it.
No, here, look, it's right there.
Oh, here it is. This is
right there.
It.
Anthony, the link to the decision is right there. Go up.
No, it doesn't go there. It doesn't go there. No,
the full text of the court's opinion. Right there.
That goes to that goes to recent opinions of the court, John. That goes to all their recent opinions. It doesn't go to this one. And then I searched for it. I couldn't find it.
All right.
So I don't think it's up yet. So this is the part that I wanted to talk. That's really interesting. This is for me because, okay, the ruling by the Federal Court of Claims is not time limited. So U.S. citizens living abroad can amend tax returns to recover excess taxes paid every year as far back as 2013. Now, why this is so interesting is usually you only have 3 years to claim a refund, but with all these cases taking so long, and imagine that if the Moors do succeed, well, what's going to happen to everybody else who paid a transition tax that they shouldn't have? And the problem is that, for some of them are on the installment agreement for it. And so maybe the past few years would go, but here we're seeing a remedy fashion, which allows, and this is what put a smile on my face, that the Federal Court of Claims says, hey, look, we're going to give you until April 15th, 2024 to claim back Obamacare taxes paid in 2013. So they're given 11 years. So they're extending this time to claim a refund. And I'm actually pretty impressed by that, because what happens if the more wins? And does that mean that the government, because the time to get a refund could expire? And so here we see at least a Federal Court of Claims saying, hey, we're going to give you time to claim refunds. And so that is why I look at this case as a pretty nice way of looking at, oh yeah, here we go. So that if more is successful, that there could actually be some relief for folks. So we're just about out of time. I'm going to ask Keith his parting shots on this. Keith, what are your final comments before you have to hop out on all of this? What would you like to add?
I don't know if I can add it that much more. I'm just looking forward to the oral arguments on the Moore case. And I thank you, especially for those who just don't know the legalese and all that, about your explanation on the amicus briefs. And hopefully the individual will be addressed during the arguments at the very minimum. So we'll see.
Yeah, and by the way, if you haven't subscribed already, please subscribe, turn on your notifications, because we will be covering that oral argument live starting at 9:30 a.m. on December 5th. It's going to be the greatest, I wanted to be a constitutional lawyer, and then I got into tax, and I wound up being a constitutional lawyer, because that's the true Constitution of the United States. And so for me, this is the biggest culmination of my 20-year career. This case is the biggest thing that will be part of my career. And so I'm really excited to be in such a great community, to have a great community to watch and discuss and react to this and share our great ideas. So be sure to subscribe. And by the way, if you are considering entering the U.S. tax system, you have questions about this, and you want to talk to a human being before you talk to a lawyer, reach out to Keith. His email is us_overseas_advocate@outlook.com. He helps navigate people through a complicated word. He's not an attorney. He's a layperson. He can just explain to you things on the reality on the ground, and things that you should do. Now, some people say all roads lead to renunciation. Some people say that. John Richardson would be one of them. And John Richardson has helped many people in tough cases expatriate and deal with the expatriation tax that they want to get you, and get it done correctly. And in my opinion, there's very few people who understand the relationship of immigration law, tax law, and actually all of U.S. code, as well as John do. So if you are thinking about renouncing, reach out to John, citizenshipsolutions@protonmail.com. John, your final words?
I have never sort of, it is the interaction, okay, of the U.S. government, this coalition of tax law professors, etc., is just so ominous and dangerous for individual American citizens. I mean, they won't even acknowledge their existence. I mean, it'd be easy for me to say, well, all roads lead to renunciation, but what people need to understand is that, they're going after a select group of people here. And trust me, with these people, your time will come.
Thank you, John. Well, thank you very much. Those are, and ominous is the word. And I think because they're all ganging up, and it's bizarre, they won't really claim that they're on the same team, but they're on the same team. And what they're saying is truly, truly frightening. Now, we're about to sign off. I want to thank John and Keith, and I just want to let you know we on Thursday I'm going to be doing a live stream at 9:30 with attorney Tom Groth. We're going to be talking about local law 18, and this was a curious law in New York that forced people not to have Airbnbs, and so there's tax implications for that. So helpful to have all these people helping you out, ruin your life so well. So we're going to be talking about options people have when your Airbnb, whether you're in New York or elsewhere, it cannot be a short-term rental, and what you can do about it. So be sure to subscribe, turn on those notifications so we know where you're going live. We love comments. And yeah, Melvin, yeah, not a very positive.
Well,
But
what does he want me to say?
yeah, exactly. It's not really positive, but he agrees, and I think that's the thing. It's like we have to look at like how scary it is.
I think you've got to look at the reality of what's going on here.
Yeah.
Okay. And this is, what we've talked about is exactly what's going on.
Yeah.
It is a total disregard for individuals generally. It exhibits a complete contempt for individuals generally. I mean, give me a reason why I'm wrong on this.
Yeah. You're kind of telling it like it is. All right. I want to just thank everyone else for participating, and we'll see you again next time. This is Anthony Parent of IRS Medic. Oh, and I should probably throw my email up here in case if anyone's trying to get in touch with me. Here's my email, aparent@irsmedic.com. Again, this is Anthony Parent for John Richardson and Keith Redmond. Thanks for watching.